All right, good evening, everyone, both here in person and for those of you who are joining us online. I hear that we have over 200 folks online, so we're really glad to welcome you here to the S.J. Quinney College of Law and to this wonderful discussion of one of my colleagues, Amos Guiora's newest books related to his Bystander Initiative. But before we go into today's presentation, I do just want to officially welcome you to the College of Law. My name is Elizabeth Kronk-Warner, and I have the privilege of being the dean. My pronouns are she and hers. And if you know me and if you've been to an event before, you know that I like to start off by acknowledging that this land that we're on today is named for the Ute tribe and is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. And the University of Utah recognizes and respects their enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. Now, the Valley used to be a place where tribal communities from around the region would come to gather and share goods and treat with each other and educate one another. And so it seems very appropriate that we continue what was that tradition in the Valley with today's presentation, which is really looking and delving into this question of the complicity of silence. And I could not be more proud of my colleague, Professor Amos Guiora, and the wonderful panelists who are here today to talk about his new book, The Complicity of Silence, Confronting Ecosystems of Child Sexual Abuse in Schools. Now, if you know Amos, you know that he is not one for demure speech. And he just before this panel told me, he said, "Thanks for coming. This is a shitty topic." Classic Amos. And while certainly it's a difficult topic, I do appreciate that he and those who've worked on this book have done so much work to surface this topic, because we know that atrocities happen, but we don't oftentimes talk about why they happen and what's the ecosystem that really allows for these things to happen. So I really applaud Professor Guiora and our panelists today who are going to talk and dive into that topic, because the reality is that we are not going to ever truly rid ourselves of these types of atrocities until we confront the ecosystems that allow for silence to continue and to allow for these things to continue. So with all due respect to Professor Guiora, this is not a shitty topic, and it's a quite important topic, and cannot be more proud to have him and here today and to talk about his book. It's important to note that this book also comes from his own family experience. Both of his parents were survivors of the Holocaust, and so this question of how can atrocities happen and the ecosystems that allow for atrocities to happen is one that is near and dear to his heart and to his family's heart for certain. So I'm excited to honor him, to honor his parents, as I know he does with all of his work that he does. And with that, I'm going to turn it over to Professor Randy Dreyer, who is the moderator for today's panel. Thanks so much, Professor Dreyer.
Thank you, Dean, and let me add my welcome to everyone tonight, those of you who are both in person and remotely. I've been assured by the IT folks that the online folks will be able to participate through the Slido app, and we hope you ask lots of questions. So we're here tonight, of course, to discuss Professor Guiora's latest book. This book has received widespread media attention and has garnered lots of acclaim all across the country. For those of you who have not yet read the book, I would encourage you to do so. I read it in one sitting. It's really quite a compelling read. But for those, let me just set the stage a little bit with a few salient facts and give you some context for our discussion tonight. So the book focuses on the murder of 12-year-old Jeremy Bell by Edgar Friedrichs. Friedrichs was a well-respected principal and a former teacher of Jeremy. The murder occurred at Friedrichs' cabin in West Virginia in the early morning hours of November 7th, 1997. Jeremy dies after Friedrichs gave him a prescription antidepressant and some chloroform, all for the purpose of being able to sexually molest him. The death was initially investigated by local authorities. No charges were ever brought, and eventually the case was closed. 5 years later, principally due to the diligent and dogged efforts of a private investigator, the case was reopened, resulted in murder charges being filed, and the ultimate conviction of Mr. Friedrichs. He is now serving a life sentence without parole on murder charges in West Virginia. But this tragic story is much more than just the perverse actions of one man. It's a tale of the depraved actions and inactions of a lot of different officials. Based on his review of literally tens of thousands of documents and court records and testimony, Professor Guiora documents the actions and inactions of numerous school and law enforcement officials in both Pennsylvania and West Virginia. It turns out that Friedrichs was a serial pedophile, and that the actions and non-actions of those numerous school officials and law enforcement officials and administrators allowed Friedrichs to victimize numerous children over a multiple year period. So in his book, Professor Guiora argues that the Jeremy Bell case is not an isolated case, that sexual abuse of children is widespread, and it's the result of what he calls an ecosystem of administrators, other teachers, and school administrators and law enforcement who put their respective interests ahead of the interests of the child. And Professor Guiora argues that it's just not enough to prosecute the perpetrator. We have to hold those, what he calls enablers, accountable. And his proposal, as he outlines in his book, is to create a new crime called the crime of enabling. And he proposes some specific language for legislators to adopt to recognize this new crime. So with that sort of general context, let's move to our discussion, and let me just briefly introduce our panel. We're fortunate to have four very distinguished panel members. They all have some connection to a greater or lesser degree to this topic tonight. Professor Guiora, of course, not only is he the author of this book, he's written numerous other books. The dean related some of his other scholarly activities. He's also the founder of the College of Law's Bystander Initiative, and you'll see information on the screens where you can learn about what that initiative is all about and how you can support it. Next to Professor Guiora is Ken Walentine, who is the chief of the West Jordan Police Department. He has served as a special master in various federal civil rights consent decrees, and he currently consults with the United States Department of Justice Office of Civil Rights. He is a founding member of the Utah League of Cities and Towns Listen, Love, and Learn Task Force, which creates strategies for police reform and improving relations with communities of color. Chief Walentine has successfully advocated for significant advances in police practices legislation that have been enacted by the Utah legislature in the past several years. So, Chief, we're delighted that you would take time to participate on this panel. Next to the Chief is Adam Sorensen. He's a trial lawyer here in Salt Lake City in the firm of Gross and Rooney. And relevant to this panel is that he has represented hundreds of survivors of sexual abuse cases by medical providers. And one of his cases recently led to changes in by the Utah legislature and a ruling from the Utah Supreme Court, which now allows survivors to pursue sexual abuse claims against medical providers without having to go through many of the hurdles that are otherwise imposed by the Utah Healthcare Malpractice Act. And then lastly, Michelle Oldroyd. She's the Director of Professional Education and Community Outreach and External Relations for the Utah State Bar. She's previously been the Director of the Utah Commission on Civic and Character Education, the ADR Director, and was a staff attorney for the United States District Court for the District of Utah. She also is an adjunct professor here at the College of Law. So we have about a little more than an hour scheduled for the panel discussion. I'm going to pose a few questions to sort of get us started off, and then we'll open it up to questions on the Slido app. And I think soon you will have instructions on how to log into the Slido app. Submit your questions on the app at any time. I'll be monitoring them, and after a few questions I have for the panelists as a whole, then we'll move to the Slido app. I have requested the panelists, I don't know how successful I'll be in enforcing it, but I have requested the panelists to be somewhat brief in their responses so that we can get to as many questions that you all have as possible. Okay, so let me begin by answering a question that I will pose to all of you. So, Professor Guiora, in your book, you note that whenever a teacher is suspected of misconduct involving a student, that there are at least three separate interests that come into play. There's obviously the interests of the alleged child victim, the interests of the alleged teacher perpetrator, and also the interests of the school who employs the perpetrator. And on page 64 of your book, you argue that balancing the harm to the child versus the harm to either the institution or to the teacher must have only what you say one clear answer. Protecting the child takes precedence over all other considerations. So let me pose the following question. I'll do it first to the panel. We'll start off with you, Chief, move down the line, and then I'll give you the last word here, Professor Guiora. So here's the question. Can any of you envision any factual circumstances where an institution's interests or the interests of the teacher may legitimately outweigh the interests of the child victim? So, or as Professor Guiora argues, the interests of the child must always be paramount. So stated differently, should the due process considerations for the accused teacher or the reputational concerns of the school be given any weight in balancing the competing interests before taking any actions against the alleged perpetrator? So, Chief, we'll start off with you.
Well, it almost seems, Professor Guiora, like I'm in a deposition, and no matter what I say, you'll say, well, that was a yes or no question. And the answer...
Chief Valentine's a lawyer, by the way, so he knows of what she speaks.
In full disclosure, many, many years ago, practiced with Professor Guiora. The answer to me is a clear no. I would say that we do have mechanisms in place to protect the privacy interests, the confidentiality interests, and even some of the institutional privacy interests as we investigate these kind of cases. But for us as the law enforcement entity, who often is coming in after someone has attempted to enable secrecy, to enable confidentiality that bleeds over into protecting an individual's interests, we often find ourselves kind of bringing that out with some painful effort. And the answer is always that our job is to protect the interests of the kids. To be fair, we find that most of the teachers, most of the educators, and most others in that same ecosystem are cooperative with us.
Adam, would you respond to the question?
I think I'll have to go with the majority on this and say no. No, as far as due process goes, speaking just from the legal aspect, due process comes with the laws we have in place that have been put together over a couple hundred years. Due process is going to happen in court. They're going to get a defense. They're going to get those protections that come there, whether it's evidentiary or whatever they are. But when we're talking about in the moment protecting the child versus protecting the reputation, I mean, I'd also argue that the reputation is best protected by protecting the child. And that you can let the lawyers that are eventually going to be hired or assigned deal with the due process of the perpetrator. That's not your job. Your job is to protect the child.
Michelle?
Well, I'm not usually one to just follow the majority, but on this front, I respond from a host of places, right? As a former student, as a teacher, as a parent, as a lawyer. And I think resoundingly the answer to that is no. The rule of law only gains integrity and public trust and confidence from protecting the most vulnerable. And if we are not doing that, then perhaps we need to reassess and recalibrate what we mean by due process. I can't imagine a time when any one of us can't picture ourselves in an elementary school classroom and what our expectations for that venue and for our treatment in that venue are or were. And I think it only becomes heightened when you're a parent dropping off a child and watching that child walk into an institution, what your sense of expectation for that institution is. And while I wouldn't want to impugn anyone's reputation unnecessarily, and while I wouldn't want a school or a school district to suffer under the weight of rumor or hunch, a child who comes forward, anyone who comes forward, frankly, in a moment of vulnerability, really ought to be believed until there's evidence not to believe them. And it is disheartening to me that we would find excuses for mechanisms and instill mechanisms in what we refer to as due process as lawyers to somehow invite a child to be honest and to be authentic and to potentially be re-victimized in a process that's trying to remedy what happened to them, while we look them in the face and say, keep telling us what you think happened, but we're not buying in, we are not supporting, and in fact, we may indeed, through our own behavior, re-victimize you as we endeavor to solve a problem. That for me is shocking. And not at all what I think of as due process or indeed the rule of law.
Well, Professor Guiora, you've obviously convinced the three panelists. Is there anything else you want to add?
So first and foremost, I want to thank obviously the Dean for her gracious comments, and to the panelists and to you, Professor Dreyer. The person who deserves one of the largest shout-outs is the private detective who worked on this case, Mr. Dan Barber, who I know is in Erie, Pennsylvania, watching this. And without Mr. Barber, none of this happens, because when he came to West Virginia and to crack the case, every step of the way, local law enforcement blocked him. And you used the word dogged, or the dean used the word dogged to describe Mr. Barber. There are no words to describe the efforts of one individual to prove that not only had Friedrichs killed the boy, but the ecosystem had enabled the killing of the boy. For me, as someone who has lived with the 15,000 pages, along with my then research assistant, Anya Korfine, who was joining us here, we made our way through 15,000 pages of documents. And it became clear as clear can be, in addition to the article that Aya and Valerie had worked on, that there was a system in place that had one goal, and that was to protect Friedrichs indirectly and the school or the schools directly. So when I talk about enablers and following on the words of the distinguished panelists, there is no doubt that there is a clear ecosystem that had one purpose, and that's to protect the good name of the school directly, and then the perpetrator indirectly. And there's one thing that I would hope that the participants, the visitors, both in Zoom and here, take away. This is a fight. This is a full-on fight against the enablers who are locked in on protecting the institution. And I understand due process, but Michelle's also right. If there's a rule of law, the rule of law says we absolutely have to go after those who protect the perpetrator. And if there's one thing from my perspective that I hope we all take away, we have to recognize that the perpetrator knows he or she is protected. And that is what is so damning, because when in this case, when Jeremy Bell and others, as we document, child after child or parent after parent came forward, they were all dismissed. They were all fobbed off, including one of the parents was a member of law enforcement. And he complained on behalf of his child. And the school district said, no, your kid doesn't understand. It's that usual hand-waving stuff. This is a full-on fight.
Okay, thank you very much for those comments. I kind of gave you all a softball question to start off with, so let me ask one that maybe be a little more challenging for you to answer. So as I'm sure you all know, virtually every state has a sexual offender registry that requires a convicted sexual offender to register on a publicly accessible website. They have to disclose their the crime they were convicted of, where they live, all the details about when the crime was occurred, and where they live, where they work, and in some states even what vehicle they drive, so that the public in the whole can know where a convicted sexual offender lives. So my question is, this only applies to convicted sex offenders, not just ones who've been charged. So should a similar public registration requirement be applied to school officials or to teachers where it has been administratively determined that the school teacher or the official was enabled a sexual predator? Who wants to go first on that one?
I turned to my lawyer, Adam Sorensen.
So the question is an administrative determination that the person that Professor Guiora is most concerned about, enablers, there's been administrative determination by the school that that person is an enabler. Should they be required to publicly disclose to the public that they have had that determination, that adjudication, if you will, that designation? And that follows them if they move from one school to another, because as Professor Guiora noted in his book, one reason why Friedrich was able to do this is he would just move from one school to another school, or from one state to another state, and continued his pedophilia.
Yeah, so I think I'd start that by, and I think Professor Guiora has mentioned this in prior books, but the first hope is that there's a law which can charge them criminally for enabling, and that comes with a sense of knowledge and intent in that enablement. And so hopefully there's also the criminal aspect of that. And so I think that makes it even more yes, because that conviction would follow that person, whether it's on a public registry or not. An administrative one, I think at a minimum you need what's similar, what doctors have, what hospitals have, where you have at least an internal system where a doctor who commits certain offenses or other things that are administratively determined, it's put on their records that all these hospitals who hire doctors can see. And so I think at a minimum, you need some level of, whether it's public or private, but at some level, some system where every school district in the nation can see that administrative decision. So when they go to hire, they know that that's occurred. So I think that at a minimum, you need at least an internal system similar to what our medical system has, where they can't just hop over to the next county, or with doctors, the next hospital, or the other state where they get privileges, and essentially start clean. So ideally, yes, I think that it would be a good discussion about whether that should be public. But at a minimum, I think you need some kind of registry similar to what our medical system has for doctors who commit similar offenses.
Okay, others? So you're kind of halfway there. You would have allow administrative determination that you are an enabler. You would require that to be disclosed to other school districts, but you're not yet ready to have a public registry that the public as a whole would be advised of that.
Well, yes.
And why is that?
I'd say it's not quite unsure as much as the hope is that there's a criminal charge to go with it, and that there's a conviction. With administrative decisions, there can be there's not as much protection, there's not as much due process often. And so I think if they're criminally convicted of enabling, yes, that should be public. I'd want to know more about the administrative process before I come down firm, yes, that should be public, but definitely not against it. I mean, I don't think it's bad having more knowledge about what a person's past has been.
And for me, part of the question becomes a definition for a community of what enabling is. I don't know that that's part of the common lexicon. I don't know that it's part of something that we know and share as neighbors, friends, family members, community members, PTA members. Would we know what a term enabling means, and would we understand it in the school context, in the administrative context of a school administering discipline, a school district firing someone or transferring someone from school to school, let alone between districts, as you allude? Could other districts then potentially know and understand a common term?
Well, suppose it's the language that Professor Guiora proposes in his book.
Well, I think that's a wonderful beginning. I think that we're in an election year, so I'm a fan of a civics lesson. This is part of the notion of a three-tiered system, a three-branch government, where the value of the legislature is that you help further the conversation and you also help further what accountability means for a community. A judicial ruling can only have teeth if the legislature gives it some, and a judicial ruling cannot be just enacted because there's a hunch or a feeling by a group of people. There's nowhere for law enforcement to go without a statute, with a charge, and there's nowhere for prosecutors to go with the evidence that they may or may not have from a school district investigation or a law enforcement investigation of enabling conduct. So I think that here again, I would emphasize the value of the legislation and the statute codifying this notion of enabling, that without that step, we really lose the ability as community members to fully understand why enabling is a problem and why it becomes necessary to hold those accountable, whether it be public or not. I don't know that in the scenario you pose, I would say that a public website is appropriate, but I definitely think an internal system where schools and school districts and other hiring entities would have access to that information. And for me, noticing that I might interview candidates in my own world, maybe it's a question that you pose in an interview or pose on an application form somehow, if you want to somehow try to get at some of that information.
All right, Chief, you have a viewpoint on this?
Oh, I do. I do. One of the reforms that you alluded to, one of the very first pieces of legislation that I had a heavy hand in drafting was a statute in Utah that opened the doors, allowed more flow of information for people who were police officer candidates. It essentially gave a blanket immunity to any employer that was giving up information to a potential police employer about that particular police officer or candidate's background. This is something that we really struggle with in the law enforcement world. We even have a word for it. We call it rogue transient cops. They go from one department to another department, and what is amazing to me is how often our police chiefs, our sheriffs, our executives don't check that information. You talked about a sex offender registry. I'm not going to ask for a show of hands here, but I dare say that of the few hundred people that are listening to us tonight, less than 10% of you have ever looked to see whether there are registered sex offenders in your community. Now, those of you who, like me, are grandparents of many, maybe you have. So assuming that the premise is that we do have some definitional language about what enabling is, I would firmly advocate for a form of registry. Now, to what degree is it public? I'm not sure. But let's remember that teachers, like police officers, like attorneys, we're all subject to state licensure. You see, we're given certain privileges by the state, by the government, and in exchange for those privileges, we have certain restrictions placed on us through our licenses. And I say to cops that, if you don't like some of the restrictions that are placed on you just because you're a police officer, remember the power that's given to you by the state. There's a quid pro quo here. There's an exchange, just like there should be for teachers. So assuming we can overcome the hurdles of enabling legislation, whether that be criminalizing, and to be sure, Amos, you and I do agree that there should be a criminal penalty for those who truly enable, or an administrative scheme for those who have proven to engage in behavior that has enabled abuse. I firmly believe we need to have some sort of reference place where we can go to. Look, the best predictor of future behavior is what? It's past behavior.
So, Professor Guiora, you got three of your panelists who are buying into the concept of sharing information after there's been an administrative determination. They're not quite yet ready to make that public. Are you satisfied with that?
So from my perspective, not only with respect to Jeremy Bell, but I want to focus, not only Bell, but because we're discussing Jeremy Bell. Jeremy Bell never ever should have had Edgar Friedrichs as a teacher or principal. That's the truth. We found in the 15,000 pages of documents a letter of recommendation handwritten by the first principal in Philadelphia when Friedrichs was shoved aside because of a claim of pedophilia. The principal handwritten letter wished him the best of luck in his future endeavors, allowed him to resign, didn't teach for a year, and when he went to West Virginia, he came with this handwritten letter of recommendation. That letter is the essence of enabling. And when we went through the 15,000 pages, and every opportunity there was for enablers to act against Friedrichs, they didn't. Jeremy Bell never ever should have had that person as a teacher. And for me, that fact absolutely has led me to at least I've convinced myself, that enabling absolutely is a crime, because there are absolute consequences to the actions, positive commission of the enabler. If not for the enablers, Edgar Friedrichs would have been in jail long before that. But hang on, if not for Dan Barber, this also needs to be said. If not for Dan Barber, Edgar Friedrichs would have continued abusing 12-year-old boys, because local law enforcement in West Virginia and the district attorney in that county 100% protected Edgar Friedrichs that night by closing the file, the case, and bringing out of retirement a medical examiner who totally, pardon my English, screwed this thing up, from my perspective, deliberately. So here you have this ecosystem that protects him, protects the good name of the school, the good name, and it not only leads to Jeremy Bell's murder, but absolutely endangers hundreds of other children. For that reason, is from my perspective, that we absolutely must view this as a crime.
But the question posed was, would you publicize to the general public an administrative determination that someone is an enabler?
Not only would I publicize it, I put it front page of the New York Times.
Okay, all right. That's a direct answer. All right, thank you. So let me ask a question that we've got from the audience. And this is, I think, to you, Professor Guiora. Is your proposal, would it apply to clergy or medical professionals? Can they be enablers? If so, why? And if not, why not?
So when I wrote my book, Armies of Enablers, which was about Michigan State, USA Gymnastics, Catholic Church, Ohio State, and Penn State University, and I interacted with Catholic Church survivors, there is no doubt that the pattern repeats itself. Every time somebody would come forward and complain, again, Catholic Church, they were dismissed. The priest was fobbed off to the next parish. Trust me, we have the same thing in Judaism. And from my perspective, the priest, yes, but more importantly, the person who is pushing the priest off to the next parish, that's an enabler, and I would absolutely prosecute them as well. From my perspective, the crime of enabling, whether it's coaches, trainers, doctors, priests, rabbis, the rest of them, it's at the end of the day, I view this through the lens of the survivor victim. One more word, Randy. I'm well aware of the criticism. There are lots of criticisms about my work. I'm aware of that. One of them is that I am too victim-centric. My response to that is that's like the greatest compliment I could get, because somebody's got to protect them.
Okay, thank you. All right, so let me ask another question from the audience. It says, most teachers cannot afford a lawyer. We are in a time when everyone blames the teacher. What do we do about those who are accused of moral turpitude? How do we balance that with due process and when a child has been hurt? Certainly, if there's a criminal let me maybe see if I can kind of interpret what the thrust of the question is. Certainly, when there's been a criminal charge, there's all sorts of due process protections come into place. But unfortunately, until there is a crime of enabling, and I don't believe any state has adopted such a proposed crime. The country of Netherlands has adopted something similar. But other than that, no state yet has adopted Professor Guiora's proposed legislative fix. So until that happens, we're left with sort of some administrative determination, potentially, of enabling. And so the question here is, how do we provide due process, and how do we protect the reputation of a school that maybe involves a allegation of wrongdoing before there's any determination of factual reliability? How do we provide those sorts of protections in an administrative context?
So I'll start with this because we've run across this. So I'm a civil litigator, so I'm not I'm not charging with anyone with any crimes, and I have run into an instance where we have brought a case against someone who immediately they were like, "Hey, I have no money, I can't hire a lawyer." Essentially, drop the claims because you're not going to get any money out of me anyway. So we've run into that before. I'd say first, before I get into anything else, the frequency of false reporting is so low that I'm not that worried. Whenever someone comes and tells me about what happened, I mean, you can find different statistics, but everything I've seen puts it somewhere between 4 and 8% of reports of sexual assault or sexual abuse are false reports. And so if we start with that, I think there's this notion of needing to protect the teacher may not be as big of a deal first if someone's coming forward and saying that they're abused. Second, they are not stripped of due process, especially in civil litigation. I mean, criminal, they're going to be appointed a lawyer if they can't afford one. But in civil litigation, whoever the plaintiff is, they still have to meet their burden, whether the defendant has a lawyer or not. They can't just walk in and just because the defendant doesn't have a lawyer, they automatically get a judgment. And then, of course, there's the conversation you have in any civil litigation as well. What's the purpose that you have with the plaintiff? I've had with my clients. So what do you want to accomplish here? Because if this person doesn't have any money, the judgment's a piece of paper. So beyond that, what's our goal here? What's the purpose of it? And frankly, I always lean toward protecting the survivor. Now, the teacher, especially if the school has investigated, what I've seen is they actually find protection through the school supporting them or others. I've also had people say, I don't have any money to defend this, and magically they come up with money for a lawyer. And so again, I'm not as worried, especially with that false reporting statistic, especially when we as lawyers do our own investigation and our own kind of vetting of the case before we bring it. We can't just we shouldn't bring frivolous cases. There's ethics to guide that. I think that's a minor concern, and it happens very rarely.
Before I say anything else, to whoever is listening that's a teacher, I would say, I am who I am today, and I have accomplished what I have today because of one teacher who was very interventional in my early life and recognized some challenges that no one else, not even my family, recognized, and just changed my life and took me from being a resource student to, had straight A's in high school because of a teacher. So thank you, teachers, for the work that you do. That said, having seen the system work for teachers and police officers, more often than not, there is some sort of associational benefit of being represented. It's fairly uncommon to not see, and I've done some work as an administrative law judge, to not see the teacher or the public employee come in with a union appointed, a union representation. It may not always be an attorney, and Michelle may be able to speak to the wonderful and challenging and thorny question of equal access to justice. I would echo what Adam said. I will tell you, I think that it's that false reporting is at a much lower level than we even hear from some of the researchers. I think it's less than 4% in my own experience, 42 years of being a police officer. So I don't get too troubled about the fact that there may not be an F. Lee Bailey in the administrative hearing. It would be nice if everyone had that kind of representation. But again, before we get to that point, there have been levels of review, and there are people who are charged with protecting the due process rights of the individual who are not employed, not contracted with the individual.
And I would agree with what's said. I come at this as the daughter of a special education teacher and the daughter of an FBI agent. So I see multiple sides here and know how challenging it can be to raise a family on a teacher's pay, to do anything on a teacher's pay. In fact, teachers are, for so many kids, as Chief Wallentine alludes, more than just a classroom figure. They're a surrogate parent. They are a counselor, an advisor, an advocate. If these words ring a bell, lawyers, they should. It's by design. It is a relationship of trust. And so that breach of trust that the child victim survivor is speaking about is worthy of endeavoring any kind of administrative process, represented or not. This person is capable, obviously, of speaking in their classroom and voicing as an adult their perspective. If counsel isn't provided, perhaps by a union or a school district, in civil litigation concepts, there are dozens of pro se mechanisms to enlist. There are access to justice offices, there are legal services corporations, there are a variety of different resources, even within our own district court network throughout the state, that could be enlisted to potentially serve if something were to be litigated formally where someone were unrepresented. The statistic in 3rd District right now is that 69% of the cases filed in the 3rd District here in Utah are filed by at least one pro se litigant, if not two. Teachers are not alone in this quandary. So to somehow claim an elevated status that something should not move forward or questions ought not be asked, I think is a misnomer. It fundamentally allows for the enabling culture to supersede the voice of a victim that has already been quieted too often.
Okay, let me ask a follow-up question relating to the role of the civil justice system in holding enablers accountable. I mean, we've seen huge monetary judgments against the Catholic Church, against Michigan State, U.S. Gymnastics, Penn State, University of Michigan, Amos's alma mater, and other institutions. Pardon?
I'm a fan, not a
Oh, okay, yeah, a fan, all right. I stand corrected. So these institutions all suffered public shame, as well as a huge monetary penalty. But these are, of course, after the fact remedies. They don't seem to have had any sort of major prophylactic effect, maybe beyond just those specific institutions. So do we need to make it easier for victims to prevail in civil suits, not only against the perpetrator, but also the institutions that enabled?
I'll start with that one. Yes, and I'll say most of those were not actually penalties or judgments; they were settlements.
Sure.
Which is in itself an admission, but also trying to protect against if they did go to trial. Because I think if they did go to trial, it would actually be more. Yes, and I think it definitely needs to be easier. We see the headlines of 1.1 billion at USC. We see the headlines of 550 million from Michigan State. What we don't see is, for instance, at Columbia University, there's a solo practitioner lawyer representing most of the women there, has recovered almost $500 million, but it took 9 years before they saw a dime. And most of those 9 years were fighting. I mean, for instance, I've got a case right now where I represent about 213 people. It's taken 3 years and the defendants haven't filed an answer. They filed a motion to dismiss. We fought through that. We went on appeal. These institutions, not only do they have protections that are built in the law through their lobbying efforts in the legislature, but they also have the monetary ability to hire really good law firms and really good lawyers who can just slow things down to the point where if justice comes, it takes a while. And so while we see these big headlines, that doesn't mean it was easy to get there. Usually it's taken a decade or more to get there. And one of the
what proposals would you have to modify the civil justice system to make it more of an effective tool to hold enablers accountable? Presumptions, short time period to go to trial? Or
no, I was going to say 100% the statute of limitations needs to change. Even when it changes. So right now in Utah, sexual battery on the civil side falls under just the general 4-year statute of limitations. There's no separate code for it. There's other statutes that the Utah legislature has passed that say, where the legislature acknowledges how it takes decades for people to work through the trauma and get to a point where they've processed it. And yet we have a 4-year statute of limitations. And while we've changed some of the laws as far as for a minor, if you're a minor now in Utah and you're abused civilly, there's no statute of limitations. But in there's language which keeps the institutions, puts them back in that 4-year statute of limitations. So I think if you allow, frankly, I don't think there should be any statute of limitations on it for the institution or the individual. But I think the first step is opening up this time period where I've got clients who were abused by an individual in the 80s and are facing a statute of limitations argument that they shouldn't have. You should never be able to escape liability for sexual abuse or enablement. And I think that's the first thing that would need to change.
Well, I've got a question here that sort of challenges what you've just said. And I have to say, I don't know the correct answer, but the question says, Utah legislature did away with the statute of limitations on civil claims for sexual abuse.
So that's true for minors. 2016, a statute went into effect which did away with the statute of limitation if you were a minor as of that date and you're abused. Now, there was a look-back period built into that for some reason our courts said was unconstitutional under a theory that I may or may not agree with. But that is true for minors. That's not true for adults. On the civil side. Criminal side, that's true. Civil side, that's not. And that doesn't apply to most institutions. That just applies to the perpetrator.
Okay. Thank you for that clarification. Okay, so Professor Guiora, in your book, in addition to urging that legislatures adopt a crime of enabling, you lay out 16 specific actions that you think should be taken to help prevent a repeat of the Jeremy tragedy. And I'm not going to go through all of them, but I'd like to ask our other panel members their views on 2 of the suggestions. The first suggestion is by legislatively mandating criminal background checks every 5 years on all school employees? That's the first question. And then the second recommendation is that we should treat enablers, not just the perpetrators, but enablers of sexual assaults in school the same as perpetrators of child sex trafficking. In other words, subjecting them to a life sentence if convicted. So let's go with the first question. Would you support mandating criminal background checks every 5 years of all school employees?
Again, you've asked a very softball question for me. The answer is yes. And you may not realize it, but there are literally thousands and thousands of Utahns that have a criminal background check done every midnight, every single day, 365 days a year here in Utah. If you have a concealed weapon permit, there is a computer-generated criminal history check. If you're arrested for any offense, it triggers an alert, and there is some investigation by the Utah Department of Public Safety. The same thing is true for police officers. So it's not a great leap. It would not be a difficult thing to do. And again, I posit that if you are a school teacher, a school administrator who has that job by virtue of a license granted by the State Board of Education, that should be a condition to which you submit. So for me, that's a very easy answer, that we should be doing that. And perhaps I'm a little bit skewed being 42 years a cop, but I think it's a fairly minor intrusion. I get a very in-depth background check done on me for security clearance every few years, and I've got warts, and some people know them.
Any other panel member disagree?
I don't disagree. I would only add that in our daughter's school district this year, if you intend to be in a classroom as a volunteer or you intend to accompany any children on a field trip, you submit your fingerprints in advance and subject yourself to a criminal background check.
Yeah,
it seems to me that the employees ought not have a lower bar.
Yeah, the University of Utah requires, if you're going to have any interaction with minors, then you have to go through a criminal background check. The question is whether there should be one every 5 years.
I was just going to add, just to coach rec soccer for my kids, I have to have one once a year. So, I mean, if that's my standard for coaching soccer where all the parents are always present, I think it should, there's no reason that shouldn't apply.
Okay, what about the second question? Treating enablers of sexual assaults in school the same as perpetrators of child sex trafficking, meaning they're subjecting them to life sentences if they're convicted.
Can I say something?
Of course, push the green button.
Can I say something before the panel answers? In terms of framing it, for me, the perpetrator or perpetrators cannot act without the enabler or enablers. And the ecosystem of enabling is what, for me, drives this entire conversation, which is why when I wrote these recommendations, I absolutely framed the enabler as critical to the crime committed, and without the enablers, Jeremy Bell is not murdered.
That's a little less of a softball question, Professor, but again, my answer is yes. Right now, I'm working on a case of factual innocence where a police officer committed an egregious error almost 50 years ago. I believe that he did so intentionally and out of racial animus. And he will escape any justice because he's dead. Nonetheless, there are people who are alive, including the prosecutor, who has raised in this particular case and will successfully raise the bar of prosecutorial immunity. And it is just making my blood boil. I do think that Professor Guiora is right. If we can have perpetrators out there who have enablers who know that the enabler can be not held to account, not called into question, not called to be punished for their enabling act, we will continue to have enablers. We can take a perpetrator and remove them and put them in the state prison. And by the way, Professor, you and I both know we don't see life sentences for those kinds of terrible crimes. It's rare. Now, we did in Jeremy Bell's case because there was a brutal murder, and thank God we had a private investigator who did the work to get us to that point, but that's rare.
Well, and further, I think that this is a matter of a cultural shift. This is a conversation that needs to start with our youngsters when they're young. It needs to start with parents before they're parents. It needs to start with educators before they sign on the dotted line at a school district to be an employee. It seems to me that this is a conversation that we need to have at so many different levels of who we are and how we relate to each other to describe what enabling really means. And in every context in our institutions, it need not just be around child sexual abuse in a school, but contemplate the other things that our institutions might be enabling, right? There are a lot of ways that we might be cheating ourselves, our companies, our centers of government and civics. We ought to be asking ourselves these questions. Can we do more? Can we do better? Can we hold ourselves accountable? And I think about a profession like lawyering where we are self-regulating. We must ask ourselves these questions. And if we're going to ask the questions of our own ethics and going to endeavor to investigate those things administratively through the Office of Professional Conduct, through our firms, through an investigation that's informal before anything rises to the level of civil litigation, then we ought to be instructing at lower levels and teaching this as a concept. Why are we not teaching this as a concept of school, of civics in general? What do we do to allow wrongful conduct to continue, and where is our civic duty? Where do we collide with that, where we have a responsibility to name something that is criminal, that is wrong, that is against the norms of our community, and how do we establish those things? We're in a time where cultural norms really are shifting constantly. And yet we still can ask those questions of ourselves and teach young people to understand them. And if you grow up with this as a concept, that enabling is a crime, contemplate that our institutions therefore shift, and this conversation is very different. If legislatures discuss the notion of enabling as a crime and enact statutes, then this conversation is very different. So for me, this becomes a question at a host of levels, not just a criminal justice concept.
Okay, thank you. Professor Guiora, you want to add something?
So I referenced earlier that I am aware of the criticisms of this project. And one of the other criticisms, in full disclosure, is that I've been accused of trying to re-articulate the social contract. And I read that as a criticism, and I actually took that as a compliment. Because for me, in the context of the enabling, exactly what Michelle says, it requires re-articulating the relationship between each and every one of us. And I'm strategically placed exactly opposite that extraordinary quote from Dr. Martin Luther King. The arc of the moral universe is long, but it bends towards justice. And either we take that seriously or we don't take that seriously. And either we protect the Jeremy Bells of the world or we don't protect the Jeremy Bells of the world, with the understanding that if we don't protect them via criminalizing the enabler, not a damn thing will change.
So, Professor Guiora, let me ask you this question. In your book, you discuss the fact that there are mandatory disclosure reporting laws that require persons who learn of possible sexual misconduct must report that information to school officials. Here at the University of Utah, we get training every year. We're told that professors are mandatory reporters, and we must report that information to the OEO office whenever we learn of that information. You argue that those laws, those requirements of mandatory reporting are not effective. And so my question is, if someone does not comply with their obligation to report knowledge of a possible sexual assault, would they be considered an enabler and subject to the criminal penalties as you proposed in your statute?
Without a doubt. If you and I are both mandatory reporters, if somebody comes to us and says such and such happened, and we turn a blind eye and we say, oh gosh, he or she is a great guy, and the usual, we know them, I know them, blah, blah, and I fail to report, absolutely. And the proof is obviously Jeremy Bell and the others who paid that terrible price because the person who should have reported didn't report.
Any other views from other panelists?
Yeah, I just want to say whether they're effective in the moment or not, you can rarely make someone do something. So whether they're effective in the moment or not, I think is one thing. But where they are effective is after it happens and you're trying to take down the person who's enabled or the person who's perpetrated, because then you've got a legally established duty that individual had. And so this comes up with Title IX a lot. When you have someone who didn't report an instance of abuse, there are Title IX laws, which then allow you both to get through governmental immunity in some cases, but it allows you a way to go after that person. The duty's established. Then you just have to establish the breach. And so what it does is it may not always be effective in the moment, but it is helpful on the back end when you're going after the individuals, and you can point to a law or a rule or reporting where you were in this position, you had a duty to report, so now we're just talking about whether you breached it and the effect.
Well, one of the valid purposes of the criminal code is deterrence, and that should be a powerful purpose that realizes real meaning. And so I think, yes, we do need to hold those folks accountable, and we need to speak about it. I've had the unfortunate experience of seeing administrators in an institution circle the wagons when we have tried in our own organization to hold a member of that institution responsible, criminally liable, for not reporting. Because, well, such a great person, it was a little mistake this time. No, it wasn't. It was a child, not a little mistake.
We've got a question from the audience on this issue of mandatory reporting, and here's the question. Some states make everyone, even private citizens, a mandatory reporter with no apparent time limit. Would this help prevent enabling? And would you support such an all-encompassing, say, law that private citizens, regardless of whether they're in a position of trust with a student and a child or whatever, but all citizens, make them mandatory reporters and therefore potentially within the purview of your proposed statute?
Yeah, I'll say the sad thing is that the inherent part of that question is that we have to make it a law. I mean, there's a common human obligation, I think, to report this. Unfortunately, we have to have people put it into law before people, one, are held accountable when they don't follow it, but two, listen to it or gives them the courage or whatever you want to say. But I mean, I think there's a human obligation too. So I think people should be mandatory reporters. Again, there's a whole conversation about what they need to report, what instance. I mean, we're assuming a lot in saying that, but there's a human obligation of adults who are able to recognize those instances who should always report, regardless of what title they have or position they have or employment, whatever it is. I think there's just a human obligation. So yes, I think that would be fine. It's unfortunate that you have to talk about whether it should be a law or not.
Well, I'm with Adam. I think that's just basically being a good human. And unfortunately, it's really not a penalty for not being a good human. I often tell folks as they, once in a while I talk to people who want to get involved in legislative efforts, and I tell them, look, if you've got a really good idea, plan on it taking 3 years. To really, it gets introduced, it gets kicked around, it gets rejected. The next year we kind of work on it over the interim, over the summer, same thing happens. And if it's a really good idea, maybe by the end of the second year, but usually the third year. I would say 30 years on this. At one end of the spectrum, culture is what is tolerated. At the other end of the spectrum, culture is what is valued, respected, appreciated, and rewarded. And so I would say to whoever asked that question, help us shift the culture. Help us turn that very slowly moving ship toward the end that says we're going to require reporting, but also toward the end where we're all trying to be better humans.
Okay, here's a question for the rest of the panel, but not for you, Chief. They wanted to exclude you from asking this question, although I think they may have misread how you would answer it. But here's the question, not for the Chief, but for the others. Should a police union qualify as an enabler if it protects an officer accused of child molestation?
Well, I'm not Chief Wallenstein, but I think I can guess what Chief Wallenstein might say. And as the daughter of not exactly a frontline cop, an FBI agent's a little different, police unions serve a distinct and valuable purpose, and membership in those unions, in any union, frankly, has value to the wider community. But a union that allows for cultural norms to be broken in their institution and then quiets the discussion of how to remedy them is really not policing. That's their first goal, is to be a member of law enforcement that names wrongful conduct and holds people accountable and says, as a community, we sit forward here and we say, this isn't what we do. And we want to work to remedy it on behalf of the wider community. So keeping quiet and brushing under rugs and putting a closet door over something to shroud it when it belongs in the light of accountability is not policing. It is by very definition not doing what it is intended to do.
Well, and I'll just say protecting, if again, this is splitting criminal and civil. If it's providing for a defense lawyer, I think there's some argument where that's okay as far as access to justice. Yeah. Agreed. Protecting as far as hushing it up, quieting it away, secreting away, that's a whole different thing, and that can't be allowed.
Professor Guiora, you're eager to speak.
So
Like you.
reticent. So while working on the book, I obviously anonymously interacted with teachers throughout the country. And one of the recurring themes that I heard, not police unions, but the role of teacher unions in terms of, pardon the expression, enabling, circling the wagon around the school and or the teacher rather than protecting the child. And I don't know enough about police unions, but I know from working on this book over the course of how many ever years that there is real concern that teacher unions in circling the wagons protect the school, protect the teacher, and thereby enhancing the vulnerability of the only person who should be protected, and that is the child.
Okay, here's a question from the audience. It says, I work in juvenile court and in highly contested divorce cases, and I have seen many cases where children have lied or made allegations for themselves or for an adult to get to an end that is being sought. We must protect all accused. How do you respond to that person?
I couldn't agree more, but as a lawyer, I think we must do all of the above simultaneously. Why does one level of protection negate another and discount the value of the other? Why can we not have process that not only allows for a victim, a survivor, even someone simply making an allegation to have due process protections while also protecting the person who is accused until the volume of evidence necessary to be sort of borne out and told becomes apparent? It seems to me we ought to be able to do both. That to me, one does not negate the other.
I agree. I'll start with this. We argued recently, and that Supreme Court case was brought up. We're not asking to put the other side at a disadvantage. We're just asking to be able to start at the same start line they're starting at. We just want to be able to start the race at the same start line, not 100 feet back, and them have the advantage. We're just asking for an equal playing field, which goes through cutting through those, whether it's a white coat, clergy, whatever the title is, cutting through all that to just have human and human. Now, I'll also say I don't think you can quite compare the lying that he's talking about from children when we're talking here about sexual abuse. We're not talking about whose house they want to live at or trying to get out of a crime they may have committed. I think this is a very different conversation where we're talking about a child who shouldn't even have to be exposed to the kinds of words and conversations that lead to be able to accuse someone of sexual abuse. We're talking about a child talking about how they were sexually abused and reporting that. I think that also falls in a way different conversation than an individual in juvenile court or a child in a divorce situation.
Well, I've gotten lots of comments from the audience who will take issue with the panel with respect to your discussion about police or about unions. And just here's one illustrative. I challenge that evidence. Teacher unions in Utah do not protect the teacher over the child.
Hopefully.
Okay, well, Chief, let me ask you this question. So, Professor Guiora, his harshest criticism is primarily directed to teachers and school administrators who place the interests of the school ahead of the child. But he's also critical of law enforcement, and it's not just the officers that were involved in the Jeremy Bell case, but he kind of casts a broad accusation all across law enforcement, claiming that too often police fail to believe victims. We see that in sexual assault cases involving adults, but even more so in when the victim is a child, that they're somehow less inherently believable, failing to engage in sort of robust police investigations, whether that's because there are more, quote, serious crimes that require attention and police departments are not as fully empowered, if you will, or have resource limitations or what have you. And that there's a natural tendency for police officers in a local community to give greater credence to the interests of the institutions, or say a respected teacher, like in Jeremy Bell's case, who was a school principal and was quite revered as a teacher. So what, in your view, does law enforcement have to do to address this issue of identifying and prosecuting and taking appropriate actions against enablers?
This very fast and firm and rewarding friendship that I have with Amos was born out of both of us exploring how to deal with bystanders, how to deal with enablers in our respective universes, and that's what brought us together. And you're absolutely right. He does not hesitate in his criticism of people in my profession or people in my position. And I would say first and foremost, if you work for me, you will often hear me say that the three hardest things in life, bar none, are these. And I think in this order: first, admitting that you're wrong; second, exchanging love for hate; and third, including the excluded. And I would argue at length in some other context that all of those fit into this discussion. What police officers need to do, what people in my position who have some authority, such as we suppose, need to do is to take that quote and say that the arc of police reform, or police continuous improvement, if reform offends you, is long, but it does bend toward justice. And it is a constant struggle for us to be changing the culture in our institution as we relate to other institutions. And I think that really what I need to do as a police chief is something that I try and do. And it's the reason that I'm here tonight. And that is to speak to the public and to speak. We have police officers in the audience, police leaders, police administrators, and to speak to you and say, listen, let's be sure that we are not those who are second-level enablers by allowing the enablers in institutions that we interact with and sometimes that we confront continue on. Let's question them when they say, oh, I just don't think that's he couldn't know. You know, I think that child, that home that child comes from, I think that child is just a liar. Let us question those. Let us confront and let us challenge those kind of statements so that we do not enable enablers.
Okay, we're almost at the end of our allotted time, so that we can still have time to talk with the panelists in the reception. But one final question. What advice would you give to parents in terms of advocacy for safety in the face of a child sexual misconduct allegation that a school is not taking seriously?
I speak as a parent and as a grandparent. First and foremost, to believe the child when the child comes forward, and that requirement to believe the child applies not only to, the Chief and I are both grandparents, correct? Not only to grandparents, but particularly to police officers, absolutely school officials, and again, not to repeat, but in the Jeremy Bell case, every parent who came forward was dismissed, dissed, fobbed off, and this hand motion.
But the question is, what should a parent do if the child is not being taken seriously?
The first thing is for the parent to take the child seriously. And the second thing is to go meet with school administrators. If you need to take a lawyer like Adam Sorensen with you, you go take a lawyer and you make it clear to the school district and police officers that you're a child who is mandated to be at school until the age of 16, that the state has one obligation, and that is to protect the child. Full stop.
You get loud. You get loud. My oldest daughter, who's a mother of two of my grandchildren, and she also happens to be a cop. Boy, if she thinks something's wrong in her school, whether it's her kid or someone else, she gets loud and she goes knocking on doors and she enlists supporters. She gathers allies. Go to your local police. And I realize we have not been perfect in the past, and we have a lot to apologize for as police officers, but we have a lot to be proud of, and much of that has to do with how well we do protect kids. Get loud and find every single ally that you can. Do not allow yourself to be shut down and to be quieted.
Okay, so the essence of that is just go raise hell and keep raising hell until someone listens to you. All right, well, we've come to the end of our time. We have a reception hour, so please join me in thanking our panel. And I'm sorry I couldn't get to all of the questions that people asked. Okay, thank you. There is can we put up the QR code for the purchase of the book?
I highly recommend it. I too read it the first time through in one sitting.
If you want to delve a little more into this issue, maybe you can put up the QR code there's a podcast that Professor Guiora was on with the podcaster Tabitha Newell, who's had several million views of this particular interview. So you might listen to that podcast as well. Okay, so please join us out in the foyer for some light refreshments. And you can, for those of you who had some quite pointed comments, you can maybe address those directly with the panel.